in those very difficult times, had the courage to wade into Hindu law and pass reform, social reform, as Mr. Munshi will say, in the context of marriage, divorce, inheritance, succession, guardianship, maintenance. When you control an institution, when you control a body corporate, or when you control a cooperative society,
It is a religious to manage its own affairs in matters of religion means, suppose there is a mutt belonging to a particular denomination. The particular head or the mahant, the guru, whatever you may say, wants a disciple. His right to select a disciple, that cannot be interfered by the state. Today, are we as a 9-judge bench going to upset the civilization is the question.
I would reframe what my lady says and say this, that the framers were confident that by reforming faith and reforming religion, they were not upsetting a civilizational balance. I think that is the confidence of the framers.
Draw a line. There has to be a line drawn.
I think that is the confidence of the framers. The fruits of their introspection, which is the text of the Constitution, which reads in a certain way, and the knowledge that Parliament, even at the time of founding of the Republic, in those very difficult times, had the courage to wade into Hindu law and pass reform, social reform, as Mr. Munshi will say, in the context of marriage, divorce, inheritance, succession, guardianship, maintenance. So to that extent, if I may be cheeky to say this, my lords, your lordships have a lesser task, my lords, than the framers did at that time, minus partition happening outside this building. Now, my lords, I'll take you to the second proposition. May I take you to Article 26, freedom to manage religious affairs. My lords have this. Subject to public order, morality and health, every religious denomination or any section thereof shall have the right, A, to manage and maintain institutions for religion, religious and charitable purposes, to manage its own affairs in matters of religion, to own and acquire property, to administer such property in accordance with law. So C and D, I'll leave out. Let us please focus, my lords, my lady, to manage its own affairs in matters of religion. Now, my lords, the word manage is not a matter of chance. It is a matter of explicit intention, because the word used is manage, not control. If the word in 26B had said to control its own affairs in matters of religion, then we would be in a zone of power and the exercise of power which is beyond this court. But the framers used the word to manage its own affairs in matters of religion. Now, why is this important?
Yes, the word manage.
Yes. Articles 25 and 26 of the Constitution must be harmoniously interpreted so that the right to manage found within 26 does not eclipse the rights under 25. The makers of the Constitution, while constructing Article 26B, deliberately use the word manage instead of the word control, which denotes legislative intention. The word manage, 26B of the Constitution, does not bestow upon religious denominations any right of control, but rather a much more truncated right of managing. The use of the word manage in place of control is intentional, as the Constitution, while dealing with other provisions, has explicitly used the word control. Now, where has the Constitution done this? May I take you to Article 243 of Part 9B of the Constitution? For one instance, which speaks to cooperative societies. May I just read that article out, my lords? It's Article 243 ZH. I've reproduced it here, definition, and this pertains to cooperative societies. 243 ZH, in this part, unless the context otherwise requires.
What purpose you are reading this?
No, I'm reading this to say that they intentionally used manage and not control, because where they intended to give that zone of power, they use control. Like, for instance, in the context of corporate.
That's home. Again.
No. Yes, my lord. Please.
There are two things.
My lord.
See, it only says manage the religious affairs.
Yes.
Affairs of the religion is definitely different than the religious belief and practice on the one hand is totally different.
Yes. But
see, a group of people, they have a belief and then followed by a practice.
yes.
That practice is being managed by them by an affair.
Yes.
So therefore, there is no need to read into 25(1) so far as this is concerned. what has been available in 25.1 is being managed and forwarded by the common belief to this denomination. It manages it. It manages the affairs. How to give effect to. Like when 25.1 says practice, profess,
That's right.
propagate.
That's right.
That's what is being done.
But it
That's
is
what this distinction is. If you say as against the instrumentality of the state or something like that, then probably the issue might come.
no,
But
my lords.
you can't use this as against individuals.
No, my lords, it's not about using it against individuals.
Yes.
It is about the zone of regulatory power that is envisaged under the text of the Constitution. Only in that context. So, if it said control, that is a higher zone that is envisaged. You can be a new denomination. You can actually recognize.
Doesn't make any difference. Whatever way you use this.
No, my lords, I think it does make.
You can say how long the power is there available for the state to regulate it, that doesn't make any difference.
The dictionary expression which you have tax dictionary, that includes, because this definition is inclusive.
Yes.
So executive, administrative and supervisory powers, all are components of management. Probably management expression has a greater autonomy in terms of that.
Yes.
And that's why in Article 30 you rightly pointing out the word establishment, then to run the affairs and to manage the affairs. All three components are there.
Yes, so may I just read this part out, my lords, on management of the affairs of the institution. There's just an extract. This is a 6-judge bench. For instance, because it makes the point on what is the distinction. So this is 2.10. Standards of education are not a part of management as such. Standards concern the body politic and are dictated by consideration of the advancement of the country and its people. This is on what management of the affairs mean.
This management, I think probably we should be very clear. This management pertains to religious affairs, not religious practices. That we
Yes, and that is all it pertains to. It is not just.
Understandable.
Yes.
Understandable.
It is administration of that institution or that denomination, and within that, a lesser degree, because there is a higher degree of control if it were not management. That's all. That's the point. That is the point.
No, Dr. Guruswamy, probably we are trying to juxtapose control with management. They are totally in separate paradigms they operate. Control is with regard to institutions which are created. If an institution like a cooperative society is created, it has a managing committee. Now, who would control that managing committee? So, the control is with regard to that committee, not to the organization. Here, it is different. You establish an organization and you manage it. So, this control is with regard to a body created of an institution. Who will be in control of that? So, they are two
So,
different
but my
things.
lord, when you control an institution, when you control a body corporate, or when you control a cooperative society, there are many things you do in addition, which you do not do when you only manage. And those things include coming together in terms of the articles of association, putting in place rules, putting in place a certain framework. Here, the degree of autonomy is a lesser degree. That's the only point I'm trying to make. That is the point, that it is a lesser degree of autonomy.
I think.
Yes.
See, Article 26
Yes.
is to protect. It is a protection.
Yes.
For example, we'll say if there is a mutt where Mahant or the mutt can choose his disciple to be the successor.
Yes.
In such cases, the state cannot interfere. That is the object. To protect whatever is, it is a religious, to manage its own affairs in matters of religion means, suppose there is a mutt belonging to a particular denomination. The particular head or the Mahant, the Guru, whatever you may say, wants a disciple. His right to select a disciple. That cannot be interfered by the state. That is the protection which is given under 26 to a denomination.
No, my lady, may I just. Yes.
You can't go and make inroads into all this.
Yes.
Put your argument this way.
Protection.
Yes.
The word manage will have to be given a restrictive meaning
That's right.
to the effect that a religious denomination cannot take the role of the believers and do it on its own. Because it can only manage what is conferred to you by under 25.1.
Yes. And neither can it create
To the
new
individual
practices.
person. That to that extent you are right.
Yes. And neither can it
So
create
now
new
you can't
practices.
have something more than what has been conferred.
That's right. And you cannot create new practices. So it
Yes.
is to that extent.
You are more like a power of attorney holder.
Yes.
And delegate.
That's right.
That we get.
That's right.
All right.
That's the point, my lords. That is the point. So, my lords, may I just take you to paragraph 2.10, manage under Article 30 of the Constitution, which also uses the word manage. There is a reason why management is the right ascribed as opposed to control. Please see this. Even the right of minorities to manage their institutions. My lords have this, paragraph 2.10, page 10. Even the right of minorities to manage their institutions under Article 30 are circumscribed as held by a 6-judge bench of the Supreme Court in state of Kerala versus Reverend Mother Provincial 1970. Administration means management of the affairs of the institution. That is the import of this word.
Protection.
Yeah.
Because they are minorities, they have certain unique, characteristics to protect the minorities in respect of their affairs. That article
No, but
30 is there.
May I just read this extract out, because I think it makes the point and answers my lady's question. May I just read this extract? My lady.
What was India in the 1950s or late 40s? What was inherited? What were the drawbacks in the society? That is on one aspect on which the Assembly has debated and given its various provisions under the articles. But the framers were most conscious of what should be protected, that the civilization must continue, and therefore they have come to certain. Articles are framed in particular way. Today, are we as a 9-judge bench going to upset the civilization is the question.
I would reframe what my lady says and say this, that the framers were confident that by reforming faith and reforming religion, they were not upsetting a civilizational balance. I think that is the confidence of the framers.
There has to be a line drawn.
I think that is the confidence of the framers. But I believe the framers were...
What is happening, the line now, we are given to understand that the line must be blurred. That cannot be.
But my lady, with great respect, I would disagree on this point, that reform in any way upsets civilizational balance. Sometimes civilizations are enhanced when there is social reform. And I think that is the point. That is the point.
We are not saying there should be no reform.
On the issue
There
of
has to be a balance.
On the issue of expression management or manage word,
Yes, my lord.
I think there is no dispute
Yes,
that
very well.
the expression manage is it rather reflects a constitutional
Lesser degree.
autonomy
Yes.
on me, but it is subject to certain conditions.
Yes, my lord.
Those conditions are, as my brother has pointed out, 25, one is there, 25 and then 20.
And part 3 also, my lords. And part 3 also. Part 3, public order, morality, but it is used intentionally. Now, my lords, page 11. The right of entry into a public temple is a subject of 25 and cannot be made subject to 26b. Now, my lords, may I just make this point, that the state has been vested with the exclusive power under Article 25(2)b to throw open Hindu religious institutions of a public character and enable entry of individuals into public temples. When a right has already been specifically granted to the state under 25, there is no conflict created merely by using the word manage in 26. For instance, in the Sabarimala case, women were historically permitted. This is in the judgment, the 5-judge bench decision. Accordingly, where a purported denomination invokes its right of management under 26 to displace an existing custom permitting women's entry into a public temple, this would be ultra vires the Constitution and Dehore's Articles 25 and 26.